opening parenthesis, continued, Pope or Inquisitor, or from a military caste, or from an aristocratic or plutocratic oligarchy, or from a ring of employers, or a trade union, or a party caucus, or worst of all, from a terrified and infuriated mob. A man's a man for that. The whole point is, whether he can make head against oppression in any of its Protean shapes, and defend the island of his home, his life and soul. And here is the point at which we may consider and contrast the constitutions of our respective countries. It is very difficult for us in England to realize the kind of deadlock which has been reached in the United States. Imagine, for instance, the gigantic India Bill, passed through Parliament and for 2 or 3 years in active operation throughout the whole of India, suddenly being declared illegal by the law lords sitting as a tribunal. Imagine, to take an instance nearer home, some gigantic measure of insurance as big as our widows' pensions, health and employment insurance rolled together, which had deeply interwoven itself in the whole life of the people, upon which every kind of contract and business arrangement had been based, being declared to have no validity by a court of law. We simply cannot conceive it. Yet something very like that has occurred on your side of the Atlantic. In our country, an Act of Parliament which, upon the advice of the ministers responsible for it, has received the royal assent is the law of the land. Its authority cannot be questioned by any court. There is no limit to the powers of Crown and Parliament. Even the gravest changes in our Constitution can in theory be carried out by simple majority votes in both houses and the consequential assent of the Crown. But we now watch the workings of a written constitution enforced by a Supreme Court according to the letter of the law, under which anyone may bring a test case challenging not merely the interpretation of a law, but the law itself, and if the court decides for the appellant, be he only an owner of a few chickens, the whole action of the legislature and the executive becomes to that extent null and void. We know that to modify the Constitution even in the smallest particular requires a 2/3 majority of the sovereign states forming the American Union. And this has been achieved, after prodigious struggles, on only a score of occasions during the whole history of the United States. American citizens or jurists in their turn gaze with wonder at our great British democracy expressing itself with plenary powers through a government and parliament controlled only by the fluctuating currents of public opinion. British governments live from day to day only upon the approval of the House of Commons. There is no divorce between the executive and the legislature. The ministers, new or old, must be chosen from men and parties which in the aggregate will command a majority in the House of Commons. Parliament can, if it chooses, even prolong its own life beyond the statutory limit. Ministers may at any time advise the king to a sudden dissolution. Yet all classes and all parties have a deep, underlying conviction that these vast flexible powers will not be abused, that the spirit of our unwritten constitution will be respected at every stage. To understand how this faith is justified, how the British people are able to enjoy a real stability of government without a written constitution, it is necessary to consider the beginning of party politics in Britain. Whigs and Tories were almost equally concerned to assert the authority of Parliament as a check upon the executive. With the Whigs this was a matter of fundamental principle. With the Tories it was a question of expediency. James II was a Catholic and his efforts to further the cause of his co-religionists alienated the great bulk of the Tory party, who were loyal to the Church of England. Then from the advent of William of Orange to the accession of George III, with a brief interval in the reign of Queen Anne, the Crown could do nothing without the Whigs, and the government of the country was predominantly or exclusively in the hands of that party. The Tories were thus vitally interested in preserving and extending the rights of the parliamentary opposition. In this way a jealous care for constitutional rights came to mark both the great parties of the state. And, as to all men the Constitution represented security and freedom, none would consent willingly to any breach of it, even to gain a temporary advantage. Modern times offer respect for law and constitutional usage. Nothing contributed so much to the collapse of the general strike 10 years ago as the declaration by great lawyers that it was illegal, and the right of freedom of speech and publication is extended under the Constitution to those who in theory seek to overthrow established institutions by force of arms so long as they do not commit any illegal act. Another factor making for stability is our permanent civil service. Governments come and go. Parliamentary majorities fluctuate, but the civil servants remain. To new and inexperienced ministers they are guides, philosophers and friends. Themselves untouched by the vicissitudes of party fortunes, they impart to the business of administration a real continuity. On the whole, too, popular opinion acts as a guardian of the unwritten constitution. Public chastisement would speedily overtake any minister, however powerful, who fell below the accepted standards of fair play or who descended to trickwork or dodgery. When one considers the immense size of the United States and the extraordinary contrasts of climate and character which differentiate the 48 sovereign states of the American Union, as well as the inevitable conflict of interests between North and South and between East and West, it would seem that the participants of so vast a federation have the right to effectual guarantees upon the fundamental laws, and that these should not be easily changed to suit a particular emergency or fraction of the country. The founders of the Union, although its corpus was then so much smaller, realized this with profound conviction. They did not think it possible to entrust legislation for so diverse a community and enormous an area to a simple majority. They were as well acquainted with the follies and intolerance of parliaments as with the oppression of princes. To control the powers and conduct of the legislature, said a leading member of the Convention of 1787, by an overruling constitution was an improvement in the science and practice of government reserved to the American states. Single quote. All the great names of American history can be invoked behind this principle. Why should it be considered obsolete? If today we are framing that constitution for a United States of Europe for which so many thinkers on this side of the ocean aspire, fixed and almost unalterable guarantees would be required by the acceding nations. It may well be that this very quality of rigidity, which is today thought to be so galling, has been a prime factor in founding the greatness of the United States. In the shelter of the Constitution nature has been conquered. A mighty continent has been brought under the sway of man, and an economic entity established, unrivaled in the whole history of the globe. In this small island of Britain we make laws for ourselves. But if we had again attempted to apply this flexibility and freedom to the British Empire, and to frame an imperial constitution to make laws for the whole body, it would have been broken to pieces. Although we have a free, flexible constitution at the center and for the center of the empire, nothing is more rigid than the established practice, namely, that we claim no powers to interfere with the affairs of its self-governing component parts. No Supreme Court is needed to enforce this rule. We have learned the lessons of the past too well. And here we must note a dangerous misuse of terminology. Taking the rigidity out of the American Constitution means, and is intended to mean, new gigantic accessions of power to the dominating center of government and giving it the means to make new fundamental laws enforceable upon all American citizens. Such a departure in the British Empire by a chance parliamentary majority or even by aggregate Dominion parliamentary majorities would shatter it to bits. The so-called rigidity of the American Constitution is in fact the guarantee of freedom to its widespread component parts. That a set of persons, however eminent, carried into office upon some populist heap should have the power to make the will of a bare majority effective over the whole of the United States might cause disasters upon the greatest scale from which recovery would not be swift or easy. I was reading the other day a recent American novel by Sinclair Lewis, It Can't Happen Here. Such books render a public service to the English-speaking world. When we see what has happened in Germany, Italy and Russia, we cannot neglect their warning. This is an age in which the citizen requires more, and not less, legal protection in the exercise of his rights and liberties. That is doubtless why, after all the complaints against the rigidity of the United States Constitution and the threats of a presidential election on this issue, none of the suggested constitutional amendments has so far been adopted by the administration. This may explain why the 9 old men of the Supreme Court have not been more seriously challenged. But the challenge may come at a later date, though it would perhaps be wiser to dissociate it from any question of the age of the judges, lest it be the liberal element in the court which is weakened. Now, at the end of these reflections, I must strike a minor and different note. The rigidity of the Constitution of the United States is the shield of the common man. But that rigidity ought not to be interpreted by pedants. In England we continually give new interpretation to the archaic language of our fundamental institutions, and this is no new thing in the United States. The judiciary have obligations which go beyond expounding the mere letter of the law. The Constitution must be made to work. A true interpretation, however, of the British or the American Constitution is certainly not a chopped logic or pedantic interpretation. So august a body as the Supreme Court in dealing with law must also deal with the life of the United States. And words, however solemn, are only true when they preserve their vital relationship to facts. It would certainly be a great disaster, not only to the American Republic but to the whole world, if a violent collision should take place between the large majority of the American people and the great instrument of government which has so long presided over their expanding fortunes. Winston S. Churchill, What Good's a Constitution? Collier's 98. August 22, 1936. 386–93. Reproduced with permission of Curtis Brown, London, on behalf of the estate of Sir Winston Churchill. Copyright Winston S. Churchill, reprinted from the U.S. Constitution, A Reader, published by Hillsdale College.